Hi, my name is Marquita Barantz, and I am siding with the plaintiff. I do agree that what was done was unethical and also somewhat illegal. This person had their medical information or their health information released without their knowledge nor their permission. Usually under the Hippa law, it does allow the medical professionals to pass the information on to those who need to know the information, such as other colleagues that may be treating the patient and or the health plan that is providing the insurance for the patient. But the information can also be passed to family members as long as the patient does not object. But if they do have stipulations on who they want to release the information to, there are waivers that the medical professionals have that states that. But in the event that the employer is involved with receiving the information, such as a supervisor, it's kind of a need-to-know basis. Why is it that that supervisor needs to know this information? They don't need to know the type of surgeries being done, the medication, or whatever treatment is going to be taking place afterwards. So that makes it a little bit difficult for the plaintiff to return back to work because it could become a hostile work environment. Not to say that the supervisor had malicious intent. There could have been some malicious intent. Thus, there's an example of a gentleman that came. This information comes from the Pittsburgh Tribune Review, July 1st, 2011. There was a 36-year-old gentleman that worked for a medical institution that pretty much was gaining access to patient files and stealing their social security numbers and birthdays and passing those information along and filing false income tax and also other legal documents under those patients' information. So that right there is the malicious intent. We don't know what one has in mind when they're gaining access to information that does not belong to them, or what reason do they have to know this information. There are safeguards in place for things such as this. As an example, if you use any type of electronic medical record system, they have the timestamps, and they have passwords and IDs that are. It is very unethical to share your ID with someone, especially if you're using an electronic filing system for your medical records. And this also allows the patients to gain access to the medical records electronically and pass those to whom they feel deemed necessary. And also that kind of cuts back on the prying of eyes. HIPAA does also have a privacy requirement in place where how the medical offices need to have their computers positioned, not leaving medical records unsupervised, or also keeping them in a secure location if they're still using the regular file with the paper, keeping them under like a lock or locked door or locked file cabinets, and making sure that whomever's gaining access to those file cabinets are personnel that needs to know that information or gain access to that information. Also, the defendant, I really didn't hear as to why that the supervisor need to know the information. As I stated earlier, the supervisor may not have had any malicious intent, but you never know that the information can be passed on, and that could cause the plaintiff to not have a job. They may return to work into a hostile work environment, or it could be their work being limited to then eventually making them want to quit because they're having the hours cut. We never know why one would need to know information, especially if they have no need to know the information. Also, this can so that's like a breach in the security and also the privacy as to whom releases information. Not only the supervisor, but whomever made that supervisor have access to the information. They will have to be held responsible as well as to what happened and correcting the issue in the future to make sure things like this don't happen on a wider scale, and something terrible could happen when information has been released without the plaintiff's knowledge. Thank you so much.